right, well, good afternoon, everyone. My name is Anthony Lombardo, and I'm here on behalf of the National Initiative for the Care of the Elderly, or NICE for short. We are a knowledge transfer network, an international knowledge transfer network, housed here at the Institute for Life Course in Aging at the University of Toronto. So I want to welcome everybody here and those of us joining by webcast to our seminar this afternoon. It gives me great pleasure to introduce Judith Wahl to you today. Judith is the founder and the executive director of the Advocacy Centre for the Elderly, or ACE for short, which was Canada's first legal clinic for low-income seniors. And we are very grateful that in what little spare time Judith has, that she donates some of that to us and sits as the deputy chair of our board of directors for NICE, a position that she's filled since our inception in 2005. And certainly we owe a lot of our successes to Judith's help and input in NICE. So it's my honor to introduce Judith this afternoon, and please join me in giving her a warm welcome.
Thank you. So what I'm planning to do today is talk about healthcare consent and advanced care planning, and I try to give it a bit of a provocative title to attract you to this, to stop the madness. I think what's been happening from our observations from the Advocacy Centre for the Elderly is that people have, with good intent, have wanted to try to help support patients, residents in long-term care, people within the health system in having their rights recognized and having their wishes honored, even when they become incapable of giving consent to treatment. However, my pitch to you is that the emphasis has gone away from getting proper consent, which is the true support of a person's autonomy, their choices, and now we are using advanced care planning in a way that in fact limits patients' rights and detracts from patients' rights. So on admission into long-term care, as an example, many people are told you have to sign an advance directive. Well, in fact, this is a matter of choice. It may not be something that people want to do. They may not want to express their wishes, or they may not want to express their wishes in the way that the institution or the health provider wants them to. And I think we have to get back to the basics of healthcare consent and put advanced care planning in the appropriate context, within the context of consent. The context, I want to mention that I am from the Advocacy Centre for the Elderly, and here's some contact information about my center. What we are, because it'll give you the context from which I'm going to be presenting my points of view on this issue. The Advocacy Centre for the Elderly is a community legal clinic. We were the first legal clinic in Canada to provide legal services to low-income seniors. We've been in operation since 1984. I'm delighted to say that the second legal clinic of this type is open in Vancouver just in September of this year. It's been a long drought, and we're glad that we have now friends in British Columbia that are joining us in this type of work. The Advocacy Centre for the Elderly, the type of work that we do is that we are a law office. We provide direct legal services to seniors, so we operate like any law firm would. We have a staff of 5 lawyers, 3 support staff, so we provide advice to clients. We are also retained to represent them before courts and tribunals. Over the years, we've appeared in every level of court, from small claims court through the Supreme Court of Canada. In addition to the client work, we also engage in a great deal of public legal education, and this area about healthcare consent and advanced care planning has been a major area of education for us over the years. We also engage in law reform activities. I, in fact, when I first started at ACE, ended up being on the various Ontario government committees that drafted the Substitute Decisions Act and Healthcare Consent Act. So I saw the work right from its beginning, and the intent, the original intent, was again to try to support people's autonomy, to get their voice heard, but at the same time ensure that there was always somebody there for that person to speak for them if they were not capable to speak for themselves. So Ontario has a substitute decision-making system. So we saw the development of that legislation over the years, and then subsequently we've been involved in various types of reform related to that same legislation as it's been going through the different levels. I also had the opportunity of working on the Alzheimer's initiative on advanced care planning. This was one of 13 initiatives that was funded by the Ontario government and sponsored by the Alzheimer's Society of Ontario to look at different aspects of responding to Alzheimer's disease and related disorders. One of these initiatives was specifically on advanced care planning, and the intent was to, again, to try to promote people doing some pre-planning, thinking about what they would want or not want, particularly people with Alzheimer's who would likely live for many years but not be in a position to be the main decision maker for themselves. So the idea was to get people to think about advanced care planning and to help them communicate to their relatives what they would want or not want when they became mentally incapable. So through that process as well, I learned many lessons, interacted with different health professionals across the province of Ontario, and I think actually in that initiative, although it was successful in that it resulted in a lot of education, a lot of promotion about healthcare consent and advanced care planning, I think the mistake that we made is that we didn't emphasize enough the healthcare consent component, and as such, people have picked up the advanced care planning part but have forgotten about the advanced care, forgotten about the healthcare consent. So that's why, again, I'm suggesting we go back to basics and look at how healthcare consent fits into this framework. I'm going to give some credit for a couple slides that I received from Chris Sherwood, who is a pain management specialist nurse in the Halton, Norfolk area, who's been working in this area on healthcare consent and advanced care planning. So looking at, starting from understanding about advanced care planning, I would put out to you, do you really understand what healthcare consent and advanced care planning is? Are you familiar with the Healthcare Consent Act? If you're working in the field, if you're working with patients, if you're involved in getting consents, do you know what the Healthcare Consent Act says? I've actually been surprised to see that in some facilities I still see people referring to the Consent to Treatment Act, which was repealed in 1996, and they've not updated their policies to incorporate the provisions of the Healthcare Consent Act. Do you look at the Act when trying to figure out the problem situations? You need to work within the legal framework. So although many hospitals, different health facilities will have their own policies about advanced care planning and health consent, it must be rooted in the legislation for it to be valid. Otherwise, you're setting up what could potentially is a real conflictual situation where people will understand what their rights are, but the policies don't match and conform to support their rights, and conflicts can occur. Does your organizational policy comply with the Healthcare Consent Act? I see a lot of effort being put into creating tools, kits, materials around advanced care planning and healthcare consent, but we also see many errors in these materials. I know of one hospital, remain nameless, that is using materials from Washington, D.C. rather than Ontario-based materials. That's problematic. The law related to healthcare consent and advanced care planning is provincial. And in the states, it's state by state. So you must look within your own jurisdictions. Materials from other jurisdictions may be informative, we may be able to learn from them, but you have to adapt the materials to fit our framework. And I can tell you there are marked differences right across Canada. I've been involved in a research project right now in creating tools around healthcare consent. And although the core elements of the consent are consistent across the country, the devil's in the details. So who is the decision maker may be different in different jurisdictions. How documents are looked at and who the documents, like advance directives, inform may be different across the country. Within Ontario, the documents primarily inform the substitutes, not the health providers. So the health providers have to ensure that they get a consent from a person in our jurisdiction, not from a piece of paper. In other jurisdictions, that may be different. So it's very important to look within your own jurisdiction and that your own policies comply with this jurisdiction. Do you understand the difference between health consent and advanced care planning? In discussions with many health professionals, we're starting to identify a series of what I would call misconceptions around advanced care planning and health consent. And some people actually think advanced care planning is consent, and that it is what they have to follow. Or they confuse what I will call care planning, which health professionals do with their patients, with advanced care planning. Different concepts, different consequences. So do people make distinctions about this? In particular, the term plan of treatment is used in the Healthcare Consent Act. And I'm told by many health professionals that this is not a defined concept that's used in a clinical sense, but yet there's a legal definition, and you can get a consent to a plan of treatment, which does include some consent to future treatments that will be, or treatments that will be delivered in some point in the future. That's not advanced care planning. If you get a consent to the plan of treatment, it's consent. It's not advanced care planning. So there's some misunderstandings about the differences, and which we will talk about today. Does your organization understand what to do if the patient has expressed wishes about treatment or admission in some way, and you think the substitute is not following these wishes? Health providers must take direction, get the consent from the patient, if capable, from the substitute if the patient's not capable. If they believe the substitute is not acting in accordance with the law, they certainly should discuss that with the substitute, make them aware of what the legislation says, which is that they are to honor the wishes of the person. But the substitute has the duty of determining whether the wishes expressed are applicable to the circumstances on which they are giving or refusing consent. So they may have a different interpretation than the health practitioner as to what the wishes meant and whether they should be applied in a particular situation. If the health practitioner disagrees with that interpretation, they can, in our jurisdiction, go to the Consent Capacity Board to challenge the substitute if they can't work it out with the substitute. But it's not enough to say, oh, I'm not going to follow what the substitute is saying in those circumstances. So is that included in the policy so that people understand what are the remedies if there are conflicts arising? And does your organization use forms for advanced care planning, and how do you use them? Forms cannot be, a signature of a form on advanced care plans cannot be used as a condition of admission into long-term care. Many long-term care homes have their own forms of advanced care plans. That's fine. People may be asked to consider whether they wish to complete such a form, but it's not a requirement. Nor is it a requirement for accreditation or for other standards within our long-term care system. Same thing in hospitals. People aren't required to complete advanced care plan forms. These are a matter of choice. So how do we get people familiar with this concept, consider what they can do, consider what they might want to do. Some advanced care planning, they can just choose their substitute and not express wishes about care for the future. And that may be satisfactory to the individual. They may want to do that, but they may not want to put down specific directions about future medical care. Many people aren't prepared to do that because they don't know. They don't know what's going to happen to them. They put their trust in their substitutes to understand their values and beliefs and to then make decisions in accordance with those values. But they don't want to sign off on a very medicalized form because they just don't feel they have yet the knowledge of the context in which to give or refuse, to express a wish or give or refuse consent. So, as to help the discussions, I'm going to give you two scenarios, and think about these as I present the rest of the presentation, and I'm going to go back to them at the end to answer them. So, in this first one, you're the health practitioner. You've been caring for a terminally ill client whose decision, after being given information about his present health condition, treatment options, risks, benefits, is for no resuscitation. So you have the capable patient getting all the information, expressing what they want. The family has been involved in the discussions about resuscitation and has supported the client's choice. Now you're at the bedside with the family as the client's death is imminent. When the client stops breathing, the family members shout, "Do something." So what are you supposed to do? Second scenario, is this a consent or is this an advanced care plan? So Mrs. Smith is a new resident in a long-term care home. Mrs. Smith and her daughter Vera were given a number of documents and were asked to sign them. And one of these is what is commonly known as a level of care form. So this level of care form sets out 4 different levels of care. So level 1, comfort care, no treatment of non-reversible and reversible conditions, no CPR, through to level 4, which is comfort care, treatment of non-reversible and reversible conditions, full CPR, transfer to the hospital. And the other 2 are levels in between. So she's being asked to sign off on this. So what is this document? Is it a consent? Is it an expression of wish on advanced care plans? How should it be used? How should it affect the care that Mrs. Smith gets in the future in the home? So think about that as we talk about healthcare consent and advanced care planning. So what we've observed in our work at the Advocacy Center for the Elderly is common problems in healthcare consent and advanced care planning. And I want to say up front, I'm saying this very respectfully, I think there's a lot of confusion. This is not trying to cast blame on people. I think there's a lot of confusion about this issue. The language is used differently between the law and the health practitioners, and I think that leads to some confusion. So what we've observed is that, particularly in our practice, which is just older people, we're acting for the older person. Average age of our clients is probably 75 to 85. What we're seeing is that health facilities, health providers are not always getting consent, particularly from the older person, and even if the older person is capable. We get frequently complaints, particularly about neuroleptics. And not getting consents to those. Organizations, I think, are unintentionally misusing advanced care plans, using them as replacement for informed consent. So you see documents that are completed and then people turn to those rather than turning to the patient. When I was doing some education with a physician around the province during the Alzheimer's Initiative, he related a story about an incident that he had experienced in a long-term care home for which he was a physician. And what he had explained was that he got a call late at night from the director of care who was asking him about transfer of one of the residents from the long-term care home to the hospital. And he was very familiar with the patient. It's a small community. He knows the people that he's being provided care for in that home. And so the nurse said, we need to transfer this woman because the kinds of problems that she's experiencing are beyond the scope of what we could provide care for her within the home. And so the doctor says, well, that's great. That makes sense. He knows the woman's condition. And then the nurse said, but she signed a form 5 years ago saying she never wanted to be transferred to hospital. So the doctor responded, well, did you speak to the woman? Is she capable? Is she lucid? Can you speak to her? And the nurse said, oh yes, we can speak to her. She's capable, but she's in pain. But we can't speak to her. So he said, well, talk to her. Confirm with her that she wants to go to the hospital for the treatment, and so that she understands she can't receive the treatment within the long-term care home. And the response from the nurse was, but she signed a form 5 years ago saying that she never wanted to be transferred. So you can see that I don't think there was any intent of any harm to be caused, but it was the concern of somehow the document had gotten some particular authority that was greater than talking to the patient. So you can see that the advanced care planning documents are being used in some ways as consents or refusal of consents when in fact they're not. And then it's causing some confusion on site as to what should be done. We're also seeing that consents are not necessarily gotten from patients when capable, or the SDN when the patient's not capable for treatment. Also, organizations are sometimes using patients' wishes inappropriately instead of making application to the Consent Capacity Board when the health practitioners disagree with the substitutes. As I said earlier, the health practitioner has to get the consent from the patient if capable, substitute if not. But they can't just say, okay, we're not going to follow what the substitutes say. If the health practitioner believes that the substitute is not acting in accordance with the wishes that expressed by the patient when capable, they should be going to the Consent Capacity Board to have the board review that issue. If they can't work that out with the substitute. Yes.
Suppose the healthcare practitioner thinks that the opinion of the patient as conveyed by the substitute is wrong.
Then that's when they should be going to the board. Because then it's if they can't work it out, and that's all obviously the first step. I would say to health practitioners, talk to the substitute, remind them about what you believe was the interpretation of the patient. When did the patient express those wishes? How did they express it? Is it relevant to this particular decision? And so sort of go through that process. Sometimes family could respond saying, oh, no, I want all the treatment, whereas the patient, in fact, had said, look, I'm prepared to not have certain treatments, particularly if people have got a heart condition, they recognize resuscitation isn't going to be of great benefit to them, but the family is concerned. It's grief. It's dealing with that loss. So then it's that negotiation period, but that's why the board process was provided, that if that doesn't work and the health practitioner truly believes the substitute is not acting in accordance with the wishes, they have that option of going to the board.
Well, what I was wondering, suppose they think that the substitute is not acting in accordance with what the physician thinks is the best thing to do.
That's a different issue.
That's the one I'm wondering about.
And that's saying, how do you work out the conflicts? Is it a second opinion? Is it trying to work through that process? Does the substitute understand? That's another issue, and that's not going to be solved by the board. The other thing I want to say is preliminary statement is that some organizations also try to get a pre-consent. And what I mean by that, I've seen in particularly admission agreements to long-term care statements such as, when you are in this home, you will consent to anything the doctor shall order for your care. That's not legal. Consent has to be related to particular treatment. It can't be obtained in advance of treatments. In that context, people have to get the information, has to be an informed consent. So provisions about pre-consent have no authority. So let's look at the basics. I'm going to take you back to the healthcare consent framework. So what I want to talk about now is, what is healthcare? Who are the decision makers for treatment, no treatment admission? Is it the patient or the substitute or the health practitioner, and why? What is informed consent, refusal of consent to treatment, to admission? And what's advanced care planning in the Ontario context? So let's go through each of these parts. So just starting from the basics, what's health care? Well, in Ontario, health care is defined as being treatment, admission to long-term care homes, and personal assistance services in long-term care. People sometimes ask, why is admission in there? Admission was put into the legislation as a particular key decision because it's so fundamental to changing a person's life. They move from their home to another home, which is the long-term care home. They're moving into a place where they will receive care on a long-term basis. In many cases, people move into long-term care and that's the last home in which they live. So it was felt it was such a fundamental type of decision that there should be a requirement for consent. So it was put into the Act as a health care decision. Personal assistance services, the provisions in the legislation are very rarely used in the Act about this, but personal assistance services would include things like bathing, eating, activities of daily living. And at first it was thought that there should be some option in the legislation to ensure that, particularly in long-term care settings, that it was possible that if a person was incapable and not agreeing to be washed, to be fed, that there should be a substitute decision-making process in order to get a formal consent from the substitutes. As I said, this is very rarely used because health professionals work with people. They know how to assist the person, although incapable, to receive those services. Now, treatment, the definition of treatment is very, very broad. And it's anything done for a therapeutic, preventative, palliative, diagnostic, cosmetic, or health-related person. So it's very broad and includes a plan of treatment. And we'll talk a lot about a plan of treatment shortly. Now, some things that are not treatment, treatment doesn't include the capacity assessment. So if you look at this list, it's things that would be to get the person to the next stage. So things like a general examination to determine whether the person needs any treatment, taking of a health history, communication of a diagnosis. This itself is not considered to be treatment. The one that people often ask me about is G, treatment that in the circumstances pose little or no risk of harm to the person. This was put into the Act to deal with non-emergent situations, so it's not the emergency, but it's clear that a person needs a fast assistance. Colloquially, I sometimes call this the bean up the road nose. So if you've got a little kid who stuck a bean up their nose and they want to get it out, they may not have the ability to really consent, but I think everybody understands what needs to be done, and so this would permit that kind of treatment. But it's not to, I asked this of a surgeon once, what do you think is treatment that poses little or no risk of harm? And they said, oh, minor surgery. That's not what is intended by this inclusion. It's really just to deal with the non-emergent situations that need some fast result. And admission in our legislation is in respect to admission to a long-term care home. So in Ontario, those are nursing homes, homes for the aged, and charitable institutions. But it does not cover moving into retirement homes. Retirement homes in Ontario, although you may contract for health services, are not health care facilities. They are actually rental accommodation covered by the tenancy legislation, in which you can purchase private care. And consent to admission is also included not only in our present legislation, but is being continued into our new Long-Term Care Homes Act. The Long-Term Care Homes Act is going to replace the other three pieces of legislation that covers nursing homes, homes for the aged, and charitable institutions, but it's not yet in force. It's coming into force probably in about a year or two. So looking at the exact framework for decision making, the legal context of decision making, I take through a couple steps. The first step, the basic rule, is that health practitioners have to get an informed consent or refusal of consent to a treatment from the patient if capable. And this is just a fundamental law. It comes actually out of Supreme Court of Canada cases in the early 70s, Hoffman, Lepp, Bribel, and Hughes. And it's the principle that you have a control over your own body. So for somebody else to touch it, to provide you with that treatment, they have to get your consent. You have the right to refuse treatment. So even if it's life-saving treatment, you can refuse it if you're capable. If the patient's not capable, then the consent has to come from a substitute. Ontario has created a substitute decision-making system so that this way a person's voice is heard via their substitute. And this was felt that this was the balancing between, in trying to get a person's wishes expressed and be involved in the process, even though if incapable. And consent always comes from a person, not from a piece of paper. So it's the patient if capable, substitute if not. Now, in an emergency, this is the exception to this, to getting the consent. In an emergency, health care providers don't need consent to treat. Again, this is based on the assumption that people want to receive emergency treatment and want to live, want to have their lives saved. So in an emergency, the health provider is first to provide you with the care, but if they know of any wishes that you express while capable, they are to honor them. Now, many times in the emergency providers may not know what your wishes were, so they're working without that context. So in many cases, this often applies to CPR. If people are aware that they didn't want CPR, the health provider can honor that wish. Taking us down to the second step, a patient, if mentally capable for treatment, decision-making, is the decision-maker. We have the right to control our own bodies. A patient can also express wishes about future health treatment. Now notice in the Ontario legislation, there's no references to advanced care planning, advanced directives, living wills. That's terminology from other jurisdictions. It's not from Ontario. What is stated in the Ontario legislation is that you can express wishes. Wishes is a very important word because it's distinct from decisions. A consent is a decision, whereas a wish is something less tangible. It's not a consent. They're not decisions. And even if an advanced care plan exists, the health provider still has to get a consent. It's not the wish. If the patient's not mentally capable, then his or her substitute is the substitute decision maker. And we have a scheme in the Ontario legislation that I'll explain a little bit later. It's a hierarchy of substitutes. You always have a substitute decision maker, even if you've never picked a person. And it ranges, it's at the top of the list is a court-ordered guardian or someone you pick by executing a document called a power of attorney for personal care. So the theme when this legislation was first created, it was you decide who decides. You pick, if you want, who would be your decision maker. And then this way, again, is trying to support that people have the right to have control over their lives, so they're picking, making their own choices as who's the substitute. But if you haven't picked, or there's no court order, then it's a variety of family members that would be your decision maker in a hierarchy. And then if you don't have anybody on that list, it would be the Ontario Public Guardian or Trustee. So you always have a substitute. So health practitioners are not making decisions for you except in the emergency when they don't have to get a consent. Otherwise, they are required to get consent from someone as a substitute.
Does it have to be a family member?
It doesn't have to be a family member, but then you would have to do a power of attorney to choose that person. Or somebody would have to go to court to get the authority to be your decision maker as a guardian, or they would have to go to the consent capacity board to get what's called standing as a representative to be your decision maker. That's where friends kick in. Otherwise, it is the family members. So it's very important to know on who's highest in the hierarchy in your own life, so that you can decide whether you wish to do a power of attorney so that that person would not be your decision maker. Also, on that list, people can drop out. And I'll use myself as an example. In that hierarchy, the person highest on the list in my life is my mother. I love my mother dearly, but I don't want her to be my decision maker. We're very different personalities. I'm a risk taker. She's not. I'm still her baby at 56. So I would prefer she not be my decision maker. Well, I could do a power of attorney for personal care to name one of my sisters who I do want to be my decision maker. But knowing how my family works, I know my mother would just automatically drop out and would concede to my sister playing that role. But that's what you have to think about your own family unit. Who do you want to be a decision maker? And particularly if you don't believe the person you don't want would drop out, do the power of attorney so that you can solidify who's your decision maker. Substitutes also can only consent or refuse consent to treatment, and they cannot advance care plan. Substitutes, if you think about substitutes, they always have to work in a specific context. The context is on the information about your present health condition and information about the proposed treatments. And then they have to make the determination as to then what to consent or not consent to. But they have to work in that context. They can't wish. You can wish whatever you want for yourself. You can speculate. I would encourage people not to wish too broadly, particularly if they don't want the wishes to be taken flippantly, because this could drive what treatment you're going to get in the future. So take it seriously. Do wishes that in fact you would want or not want in terms of the treatment. But you're working out of a context when you're wishing. If you're advanced care planning, you don't know what's going to happen to you. When you become incapable, your health condition may change quite dramatically, and so will never be able to really figure out all the different options you would want or not want, because it's based on what your present condition is. And substitutes have to follow the wishes. Now, if you notice, I put on the slide, applicable under the circumstances of a patient when making treatment decisions. And if they don't know what your wishes are, then they are to act in your best interest. But that term, applicable under the circumstances, I interpret as meaning that the substitute just doesn't look at the wish and say, oh yes, that's what we have to do. They have to interpret it. Does it apply to this particular decision that has to be made? Is it relevant at this point in time? Does it make sense in the context of the person's present health condition? And so they have an interpretive role in dealing with the wishes.
Next question.
Yeah.
I'm sure there is no short answer to this, but is that past slide, does it sort of encapsulate what went wrong in Manitoba with that poor soul, with the family who wanted to...
Oh, the Golochuk case.
Yes. Is that where, and I know it would probably, someone's going to write a book about it, but is that the issue between the consent to treatment and the advance? Like, he would have wanted this?
Well, if it shifted to Ontario, that would have been some of the thinking, is what would he have wanted or not wanted, the families then trying to follow the wishes. Manitoba has quite a different system. They actually don't have a substitute decision-making system as detailed as ours. So there's some issues around that. But also, they don't have the consent capacity board. If that had taken place in Ontario, it actually probably would have ended up in court, just as it ended up in Manitoba, where there was the debate. One of the problems with the court system, it takes so long, so the case never got through to its conclusion. And in the interim, the judge had ordered that the health practitioner should continue to treat the person pending the final court determination. And the man died in that period of time. If it had taken place in Ontario, it would have gone to the consent capacity board first, and there would have been a hearing around, is the substitute acting appropriately under the circumstances? There would have been a different forum, a much faster forum for it to be addressed. It's not a total resolution, though, because you can appeal from the consent capacity board to the courts. I think that case, it involved a family taking the position that their father would want to be treated through the course of his disease and to die a natural death. And the family was refusing things like the no resuscitation. They were insisting on certain treatments. That's an area that I think we're going to see a lot of discussions on in the future as we have the technology to keep people alive much longer, is when is enough enough? When is the question called? Whose values and beliefs are to be followed in those circumstances? And I think that's going to be a very difficult area that needs both law reform, but also it's the meeting ground of the clinical and the law. So what's the right answer? I know in England, I was reading some recent news reports. I don't know the law in England, but my understanding from the news clips was that health practitioners can decide to discontinue treatment at a certain point. And there's been some debates around certain cases in England about this. So we're seeing it in other jurisdictions, is who has the right to decide. Not totally addressed by our laws yet. Now, Decisions which are consents versus wishes. I do draw that distinction. I think it's in the legislation. Health practitioners must get consents that are decisions, that are obtained from patients after the patients have information. So they know what their present health condition is, and they're given the information for an informed consent. But wishes are not decisions. Wishes are speculative. They're often made without all the information. So somebody, as an example of the person with Alzheimer's disease, they've been diagnosed. They know that they're going to have a period of time, likely in their life, when they are not capable. They may want to express wishes about what the future care is for themselves. But it's speculative. They don't know. They could be a very healthy person, although incapable. Or they could develop a terminal condition and be incapable. So what do you want in those different circumstances? It's very difficult to speculate and to know what's the right thing out of a vacuum. Also, many people, as they become ill, change their minds about what they would want or not want. So they would think, I've heard this expressed often by people who are young, I could never live with a disability, I could never manage that. Yet, faced with that circumstance, you see many people say, no, I can do this, it's not what I thought it was going to be, and they really change their attitudes about what they can tolerate or not tolerate, or what they think is a quality of life. It changes depending on your circumstances. So it's very difficult to speculate. So again, I think our legislation was drafted to make that distinction is, yes, we want to know what people want. At the same time, it can't be so definitive, because that could be really causing harm to people in the end, because they're working without all the knowledge base. Now, consent also in our legislation can be to one treatment, or it can be to a plan of treatment. And this is significant because of the definition of plan of treatment. Plans of treatment under the law are considered to be a plan that's developed by one or more health practitioners. So it's the whole series of health problems the person has and the various treatments that they would have. And it can deal with health problems the person is likely to have in the future given their present health condition. So some things you can know of again, it's not a perfect science, but you can see the person's going to progress through different stages. So the plan can provide a consent to a whole series of treatments. If you think of it even like in a surgery is not just the person, the surgeon cutting the body. It's a whole series of things that are being done by a variety of health practitioners. You've got the person who's dealing with the anesthesia. Thank you. You've got nurses in the room. You've got the anesthetist. You've got the surgeon. There may be other doctors there. So and there's a whole series of things that are going to happen post the surgery. So it's really, the plan is for the whole series of things that are going to happen, not just the actual surgery itself. The definition of plan of treatment also specifies that the plan can provide for the administration to the person of various treatments or courses of treatment, and may in addition provide for withholding or withdrawal of treatment in light of the person's present health condition. So if you think of the person who has got a poor heart, they may not be a good candidate for resuscitation because of the condition of their health condition. And so they could indicate that they don't want resuscitation. And although that may be a future act, they're consenting to it in the context of their present health condition, and it's based on full information. In that context, it's a consent. So decisions can be for present care and for care taking place in the future. So that's, I just emphasize this. If you look at that definition, it includes that whole series of things. So this is, I think, is a common misunderstanding within the health system, is people are thinking, well, things like no CPR, it's a future act, but yet it can be a consent to what is a future act in the context of the person's present health condition. So treatment taking place in the future is not necessarily an advanced care plan. Again, you got to keep on going back to what's the person's present health condition. What's valid consent? Consent also has to relate to a specific treatment. It can't be so overly broad that you're consenting to just anything. It has to be specific. It has to be informed. And informed, in the next screen I'll show you the definition of informed. It has a specific meaning. Consent also has to be given voluntarily. So if somebody is told, well, you must consent to this or that as a condition of living in a place, that's not consent. At one point, I know we had seen that some long-term care homes were telling people that they could not get resuscitation if they moved into that home. So, and that is I would take the position is inappropriate because there may be people that in fact are good candidates for resuscitation, although in a long-term care home. It must be remembered in Ontario, people who live in long-term care can be anywhere from 18 to very old age. So you do have people who are much younger, who are living in that environment for good or for bad. That our system is not got the best housing across the province to accommodate for a lot of younger people. But you see, actually now you see quite a few people with developmental disabilities as institutions have closed down. But if they're older, they've got health problems, they end up in the long-term care system. And so many of them may in fact be good candidates for resuscitation. So you can't have blanket policies. And also valid consent, it must not be obtained through misrepresentation or fraud. What's informed consent? For an informed consent, people have to be given information about the nature of the treatment, so what is it, the expected benefits of the treatment, the material risks, side effects, alternative courses of action, and likely consequences of not having the treatment. So the information is quite a bit of information that has to be delivered. Nature of the treatment, benefits, risks, side effects, alternatives, and what happens if you don't have it. Now, people can refuse some of the information. Like I know my own relationship with my own physician, I place a great deal of trust in her. I probably don't get all the details about all the information and an informed consent because I'll say, okay, that's enough. I actually had surgery, emergency surgery in British Columbia when I was out on a vacation. How lovely. And it was very interesting going through that process of getting the informed consent to abdominal surgery. And I was given all this information. And at one point I did say, okay, I've got enough. And the nurse was joking with me, and he said, well, you're a lawyer, I'm going to give you more information. but certainly the patient has the right to control the extent of it. But this is the basic framework that you have to work within. So when we're talking about advanced care planning, which I'm going to get into in a minute, think of those last two slides about informed consent and consent. What's composed in that? Because it indicates like if you have that information, you'll be getting consent. And if you don't, it may be just advanced care planning. Who gives or refuses consent? Well, in Ontario, consents always come from people, not paper. And that's very important to remember. Our legislation was deliberately drafted in that way. They had actually looked at those options as in some U.S. states, where the directions could come from the document. But it was determined not to do an override to the health consent process, and instead we opted into the substitute decision-making process. So you need a person. So it's important the health practitioners understand who's giving the consent or refusal. Is it the patient or the SDM? And this depends on whether the person's capable or not. So obviously this begs the question, what does capacity mean in this context? Well, capacity is also defined in the legislation. It's a legal definition, so it's not the clinical determination. Clinical skills can be are used in making this determination, but really it's based on a legal definition. So really what the health practitioner is doing is a legal assessment of capacity, and it's whether does the person have the ability to understand and the ability to appreciate the decisions that need to be made. ability to understand, ability to appreciate. Clinical assessments underlie diagnosis, treatment recommendations, and they may identify social supports. But the legal assessment, when the health practitioner is doing the legal assessment of capacity, they're deciding who decides. Is it the person, or is it the substitute? And it's the legal assessment that makes that determination. So it's a little bit different than what you're doing in a different context about the treatment. So here's the definition of capacity that's in the Healthcare Consent Act. And as you can see, it's the ability to understand information and ability to appreciate the reasonably foreseeable consequences. It's an analysis. Understanding is often explained as the details. Do the person understand the facts? Can they absorb the facts? Can they retain the facts about a situation? Do they understand what surgery is as opposed to something else in terms of treatment? Appreciation is like connecting the dots. It's more can you understand that although you can't observe that you've got an injury, that you need the treatment. That may be one example of that. So it's going on that other plane of thinking. It's reasoning it out. Mental capacity for treatment is not the score on the mini-mental status test or any other test. Again, this was long debated at the time this legislation was being drafted as to whether they would put something like that into the legislation. And it was decided that that was not the appropriate way of looking at it. That the test, any kind of test usually contains some kind of bias. But my understanding is the MFC, if you're got higher education, you're North American, you've raised in a certain culture, you're going to likely to score higher than other people. So it is a useful test. It has its role, but it's not the test of capacity for the legal determination. Also, mental capacity for treatment is not a diagnosis. So it's the fact that somebody has Alzheimer's disease and has that diagnosis, they still may be capable. They may be capable at different times of the day. So you really got to look at what are you getting, what is their capacity for a particular purpose. Capacity is also issue specific. It relates to a particular task at hand. So people can be capable for some treatments and not others. Good example of this is children. There is no bottom age for consent in Ontario. Children can actually give their own consent to treatment if they are capable for that purpose. So you may have a child who can understand if they see say that they fell and they scraped their knee, they can see that there's a blood, and so they understand they can understand and appreciate they need that to be taken care of. But they may not, as a young child, understand what surgery is, because that requires a greater level of appreciation.
I was just going to say they normally don't consent to after the scrape and don't put that stuff on me. Don't touch it.
That's true, and this is where you wonder if they're capable at that point.
Oh, they're right here. They don't want to be.
This is when you use your skills with your children. So really, capacity assessment is an analysis. It's an analysis based on observation of the ability to understand, ability to appreciate. And so just because a person is old doesn't mean they've lost decisional capacity. And this, I emphasize this particularly in the long-term care settings. There are a number of people who are still capable and should be the decision maker in that context. Who assesses capacity? It's the health practitioner who proposes the treatment. They're required to assess the capacity. Or it can be one health practitioner on behalf of the team. But if it's one on behalf of the team, they have to be prepared to give the information and get the answers to the questions that patients may have in the course of that. And they're assessing capacity. Other health practitioners are relying on that assessment. It was interesting, when I had surgery, I've actually found that, again, an interesting process, because although initially it was a nurse that was assessing my capacity, I could tell that was the process I was going through. The surgeon actually met with me just prior to the surgery and chatted with me both because, as he expressed to me, he wanted to make sure that I was comfortable and that I did understand what was going on. But he did say he was determining whether I was capable of giving the consent to the treatment. He was just doing a double check on it, just as for his own assurance. Now, where does advanced care planning fit into this whole context of consent? We've talked about what's an informed consent. We've talked about the differences between decisions and wishes. So what's advanced care planning? Well, advanced care planning often is described as the care and treatment that people want in the future when they're no longer mentally capable about decision making. So it's how do we assist people in having some control, some input into what will be happening to them in the future. Advanced care planning, some people think it focuses primarily on end of life, but actually could be about all care treatment over a course of life. I also encourage people in expressing wishes, particularly if they have Alzheimer's or related disorders, where they may be living for a period of time in different health settings, or to express things in advanced care plans about their likes and dislikes. That could be very informative in providing care, because it could be information that can be used to understand what are the triggers to people's behaviors. So to express things about their likes in music, anything that's important to them, so it's understanding of who they are as a person and what they want to be understood as a person. In advanced care plans, people can also express wishes about their values and beliefs. So it doesn't have to be a medical model kind of advanced care plan. People can express, but as I have expressed to my sister, who would be my decision maker, I've said to her, I don't have fear of disability. I place a very high value on life. If it's issues about experimental treatment, if that's going to give me a quality of life, do that. But giving her an idea of some ways of feeling comfortable in then taking some risks in providing my care and making decisions about my care. And so it's what are the values and beliefs that people want to convey to the substitute. Ultimately, I think of advanced care planning as supports to your substitute. You're trying to give them confidence to make the tough decisions for you when they have to play that role for you, because it's very difficult. It's very challenging. People are second-guessing themselves. The advanced care plans can assist them in giving that person comfort and confidence. Advanced care planning in Ontario does not need to be in writing. It's clear in the Act that you can express wishes orally. And so and that's one of the challenges. The substitute may be getting information from the patient when capable that is different than what that patient is conveying to the health practitioner. So I think of in long-term care homes, many residents become very close to staff. They may say some things to staff that they aren't conveying to their relatives. And I think it's important in those settings that the staff encourage the patient to communicate those wishes to their potential future substitute, so that their conflicts won't arise when indeed the substitute has to step in, and then there isn't the conflict between the health provider who's saying, oh no, your relative didn't want this, and the substitute is saying, oh no, you don't understand, they did want this. So the oral wishes are valid ways of expressing how people want to communicate their wishes. Wishes can also be expressed at any time, as long as that person is capable in respect to what they're expressing a wish about. So this could be even if they wrote down some kind of wishes in a written format, later oral wishes trump the written document. So again, that's why the system is set up that the health practitioner has to get consent from a person. The patient of capable substitute not, because the substitute may have other information that the health practitioners don't have. Problems with advanced care plans. I think when this all started with advanced care planning, everybody thought, oh, this is a great idea. We're going to be able to have some control over our future care. But it's very problematic. There's a very interesting article that I read, and unfortunately I forgot to get the reference. I was going to bring it, but it's from an American health journal, and it's called Enough. And it's about advanced care planning, because again, I think the writer was expressing similar concerns that I've had, that people are so focusing on the advanced care plans, they're not getting the consents. And it's because advanced care planning is not a perfect science. Wishes change as health conditions change. I know myself, as I have aged, I have different wishes, expectations, understanding what quality of life is for me now than when I was 20 years old. So even and if a person has, I know of many friends who've had very serious health conditions, and their attitudes towards what they would want or not want have changed dramatically after experiencing the health condition. Wishes may be communicated by the patient to their future substitute that are different than what they earlier expressed to the health team. So we sometimes set up things for conflicts, which just because we can do oral wishes, people do change their minds. It's not possible to anticipate given illness. I didn't anticipate I was going to have major surgery when I went on a vacation. It happened. So things can happen to people. Vague language leads to misinterpretation of wishes. I can think of one story that was told to me by a client where she had expressed some concerns about doing advanced care planning, and she and her husband actually had torn up the documents they had drafted. And the reason they did that is that they had both written out documents in which they had expressed that they never wanted to be on machines. And that was something fairly loosely drafted in that sense. And they didn't want heroic measures. So they ended up being in a car accident together. The wife was fine, but the husband was injured in the accident, and quite severely injured. And so he ended up in the emergency room. The wife was hysterical because she saw that her husband was being placed on all kinds of machines in the emerge. And she kept on shouting out, no, he doesn't want to be put on machines. Now, because she was so distraught being in the accident, I think fairly the health practitioner said she's not in a condition to give consents under these circumstances. She's not thinking clearly. And they just treated her husband in the emergency on an emergency basis and did do the treatment. Well, in the end, after the fact, the wife went to the husband. He did recover. And she said, oh, I'm so sorry, I didn't follow your wish that I didn't stop them from putting you on machines. And the husband responded, well, of course I wanted to be on machines. That was to save my life. What I meant by not being put on machines, I didn't want to live my life being maintained by some kind of technology. Very different interpretation. So it's thinking through, if you're writing down these wishes, make sure your substitutes understand what you mean by it and can put it into context. But you can see the language can be confusing. It can be interpreted in different ways by different people. And treatments change as science advances. So you can't anticipate what would have been done. I had a client who was a Holocaust survivor. And one of the things, because of her experience during the war, she said, I never want surgery. And it ended up that the kind of surgery she needed when she was much older could be done laparoscopically. Well, that had not been, what she was concerned about was being cut open, so it was very interesting. She did finally consent to the surgery because it was a different context. It was not something that she felt that she couldn't appreciate and in circumstances couldn't tolerate. So people's life experiences may lead it on a path. There could be alternative ways of giving that treatment, and which she would consent to. Options for advanced care planning: you can express wishes orally. They can be written documents. In Ontario, the document is called a power of attorney for personal care. We don't have what the term advanced directive I think of as the generic term. But I put it on here as a different kind of written document because sometimes people write out their wishes in these forms called advanced directives or living wills. But in Ontario, what is mentioned in the legislation is a power of attorney for personal care. And also people can express wishes by other means. So if they use alternative methods of communication, like a communication board, that's a valid communication of their wishes. So wishes expressed orally. This was put into the legislation because sometimes people don't want to write things down. I remember one client saying to me she didn't want to tempt fate by writing things down, but she was quite willing to talk to her family about what she wanted or didn't want. Does your mother is like that? So this is why in order to respect the person's autonomy and their participation in this process, the oral wishes were put into the act. And also, the wishes could be recorded in a chart, in a home. People are expressing that in the health setting. But people cannot be required to sign a facility advance directive as a condition of admission, or be required to put their wishes in writing. I know this is a concern by many people that they feel that they're being told that they have to do this. But they don't. It's an option, and I would encourage facilities to look at alternative ways of talking to people about this and get away from the written forms. It's not the paper, it's the communication with the person. That's what's important. So how do you do that communication? Written wishes can be in the form of a power of attorney for personal care. As I mentioned, this is the document in Ontario. It's a document in writing in which you name somebody to be your substitute. And in it, you can express wishes about your future care, or you could leave it without any kind of direction. You can also express your values and beliefs. That document also has to be witnessed by 2 witnesses who are present with you at the same time you sign it. And you have to be mentally capable at the time you execute a power of attorney for personal care for it to be valid. As I mentioned earlier, this is the method that was put in the Act that you could choose who will be your decision maker in the event that you become mentally incapable. But it has a particular format. It's not a particular form, it's this format of naming a substitute, being witnessed by 2 witnesses who have witnessed you signing at the same time, and you have to be capable. You can also express your wishes just on a piece of paper or on these various different forms that are called advance directives or living wills. But that's not listed in our legislation. In our legislation, all of those things would be wishes. And as I said, you can express your wishes in any format you want. Some people like forms that are very medically oriented, and they can tick off, I want this, I don't want that, I don't want this. Other people like the value statements, prefer that kind of model. But we do not have living wills in the sense that in some U.S. states or some other provinces in Canada have health directives. We don't have that specific format. What's most important about this is that only a power of attorney for personal care in that formalized form with the witnessing gives authority to name a substitute. So if you had, I'll say, a living will in which you named somebody, you named your friend Mary to be your decision maker, but if it wasn't witnessed by the 2 witnesses and you signed at that same time, it would not give authority to Mary to act as your substitute. It has to be that in that specific format for the power of attorney to be valid, to give authority to the substitute. I mentioned again, people can't be required to sign facility forms as a condition of admission. It's only the patient, when capable, can sign the advance directive or living will. Substitutes cannot advance care plan. They have to work in the context of consent. Who does the advance care plan speak to? Wishes, advance care plans are directions to future substitutes, not to the health practitioners except in the emergency. You can see again, I'm repeating that same mantra. You got to talk to a person and getting a consent. Who do you get the consent from? Patient is capable, substitute is not. The wishes inform the substitute because they then have to determine what wishes are applicable under the circumstances to the consent that they're being asked to give or refuse. So people could do these other forms, these advance directives. Those are still have to be used by the substitute in understanding what the person would want or not want. Substitute's role, substitutes cannot advance care plan, but they have to give consent. Now, they can consent to the plan of treatment. I loop this back to the plan of treatment. Here's that same definition of plan of treatment, which can talk about withholding or withdrawal of treatment. So a substitute, if can consent to a no CPR, if it's the person's present health condition is such that it would be valid to talk about resuscitation and whether that treatment will be offered or not. So in that context, they are not advanced care planning. They're giving or refusing consent because they have all the information. They have the context of the person's present health condition. They know the risks, the benefits, side effects, all of that about the possible treatments, and they're making a decision based on all the information. They are not speculating. Who are the substitutes? This is the hierarchy that's in the Healthcare Consent Act. Just briefly, the top of the list is a guardian of the person. So this is a court order. There's very few court-ordered guardians. Because we do have a hierarchy. Usually people do powers of attorney, or there's a family member that steps in. But somebody could go to court to become the guardian. You sometimes see guardianship orders when there's conflict between people lower on the list, and they're fighting over who's going to be the decision maker. So then they go off to court to try to get the court order. The second on the list is the attorney in a power of attorney for personal care. So this is the person you choose to be your substitute. You can choose more than one person in a power of attorney for personal care, so you can name 2 or 3. If you're naming more than one person, do consider whether those people can get along. I'm often saying to people, just because you have 2 kids, it may not be the best thing to name both of them because they may not be able to agree. Or if you have 3, 2 of the 3, would be majority rule something. But really think about why you name a person. I encourage people to name people that they can trust and that they believe will follow what their wishes are and respect their values and beliefs, but not just pick people to be the attorney just because I'm related to that person or just because it seems to be right. To really think through what is the reason why you're naming this person, because they're going to have a tremendous amount of authority. They're going to be able to give or refuse consents to treatment. So they could actually deny you treatments in the process. So think very seriously of who you appoint. The third on the list is the representative appointed by the Consent and Capacity Board. What this is that somebody can apply to the Consent and Capacity Board to be named as the decision maker in priority to your other family members. I sometimes think of this as the cheap and cheerful way of getting a fast resolution of a dispute between battling families. So say that I have 2 sisters. If both of them were fighting about who was going to be my decision maker, one of them could go to the board and ask to be appointed over the other. Now, the other sister would have to be served as part of that application. She's not left out of the process. But it is a fairly fast process. The board, if asked to make a ruling on something, has to make a decision, has to have the hearing within 7 days of being asked to make a decision, and then they have to make a decision within 1 day of having the hearing. So you could have a hearing within a fairly short period of time. With court, it could take a couple of months to go through the whole court process.
By then, the patient may already have deceased.
And that's exactly why the comment was the patient could be deceased in that whole court process, and that's why this was put into the consent, given some authority to the Consent Capacity Board to try to do a resolution of the issue in a much faster way. Spouse or partner. Spouse, in Ontario, spouse is defined as it could be same-sex or opposite-sex spouse, but it's also somebody you've had a child with or you've lived with for a period of more than 1 year. So people could actually, I've had one situation where people had multiple spouses. It's quite interesting. And you get the little conflict that's going on. Partner is somebody you live with, but it may not be a sexual relationship, but it's a relationship of primary importance in each other's lives. So it's trying to capture different kinds of family configurations. Then children, you have multiple children. The children all equally rank along with your parents. And the other, the CAS is the Children's Aid Society. Because this again, the Healthcare Consent Act, there is no bottom age for consent for children, for getting consent. So children could be capable, but Children's Aid Society may have authority as substitutes. If you have equal ranking people, so in case of my sister, she has 2 children, they equally rank, and if they can't agree, or they can't decide which one of them will be the decision maker, the decisioning goes to the public guardian or trustee. So there's an opt-out to deal with the disputes. So the health professionals don't have to continue battling with the families. They can go to the public guardian trustee. Then you see the parents with the right of access, brothers and sisters. Any other relative, this is by marriage, by blood. If you think about all your relatives, of which many of us have many, would you want some of those people to be your substitutes? And then if you don't have anybody on the list, it's your public guardian trustee, the public office. I'm just going to skip the definitions. The list is hierarchical, so you look at who's the highest in the list in your life. All persons on the same level have equal ranking, and the person always has a substitute. So even if a person has no family members, or no family members available, then it's the public guardian trustee. Now, just because you're highest ranking, you also have to meet this criteria. The substitute themselves must be capable. So I'm often asked this question about substitutes where the spouses may have named their other spouse to be their attorney and a power of attorney for personal care, but then that person becomes incapable. Well, then they drop from the list. So even though there was a power of attorney, because the person's not capable, they can't act as your decision maker because they themselves aren't capable. They have to be at least 16 unless they're the parent of the incapable person. They have to be not prohibited by a court order or a separation agreement from acting as a substitute. So although people so you could still have spouses that have a relationship together, they haven't yet formalized the separation, still potentially being a substitute. They have to be available, and they have to be willing to act. So if somebody is in availability, it depends on the circumstances what availability means, is how fast does the patient need a decision. So that's, you've got to think, an availability, people could be available nowadays by emails, by telephone, and they have to be willing to act, so people can drop out of the list. Now, substitutes, when making decisions, they have to follow the wishes of the patient expressed when capable that are relevant to the decisions. But remember, the term in the Act is applicable under the circumstances. They have to decide, is it applicable? And if no wishes are known, they act in the best interest. There is a specific definition of best interest in the legislation that helps people decide. I'm going to skip over some of this stuff because as we're running out of time. The important thing is that let's look at the 2 scenarios. So if you've been caring for that terminally ill patient whose decision was, who was given all the information about the treatment, and they made the decision about resuscitation to have no resuscitation. No, they were capable when they were doing that. The family was supportive, but now that the patient is dying, the family is saying, do something, do something. What do you do? Well, in this circumstance, based on all the things we've been talking about, does the nurse have consent? Consent to what? Did the patient do an advanced care plan, or did they give consent to no CPR? Does the substitute have a role? So here, we have a capable patient. They did get the risks, the benefits, the side effects, all the information, and they decided to have no CPR. So it's not an advanced care plan, even though the treatment is in the future from the time they were giving the consent. But it related to their present health condition, and they had full information. So they're giving a consent. So the patient is the decision maker, not the substitute. So it's important then to understand what's a decision, who's making the decision, how is it made, what's the difference between the consent and advanced care plan. giving you the logic behind this. If you look over time, advanced care plan is about planning in advance for future situations. You have discussions about CPR occur in advance. Is this an advanced care plan? No, it's not. But if you look at it a slightly different way, discussions about the CPR happened and consent was acquired. So they have a current plan of treatment that says no CPR. You have a plan of treatment. Do you have a consent? Yes, you have the consent, because the person made a decision with the full context of all the information. So, quoting from Chris Sherwood, the nurse, it's about the plan of treatment and whether consent's been acquired, not so much about the timing when treatment is performed. So that needs to be understood in determining what's consent, what's advanced care planning. And looking at the other scenario with these level of care forms, here Mrs. Smith is being asked to sign off on this level of care form. Now, is the level of care form a consent? Is it an advanced care plan? How is it used? Should it be used? So you look at this, is it a consent? Well, is it specific to treatments? Not really. It's so broadly worded, it's not specific. What's a non-reversible condition? I have high blood pressure. Maybe it's reversible if I lost weight, took better care of myself, but basically I've been taking medication for years. Is this something, would I want other treatments if just because I have this condition that may be non-reversible at this stage in my life, would I want other treatments? Of course I would. I'm a healthy person. If I had diabetes, would I want, that's not a reversible situation, would the person want other treatments? Of course they would, in most likelihood. So it's what is this form? What guidance is it really giving? Is it an advanced care plan? Well, maybe. It's quite broadly worded. So if you think about if Mrs. Smith is capable, she's the capable patient, she's really had no information on her present health condition when she's being asked to sign this thing. She's being just told, you got to sign this as a condition of admission. She has no information about specific treatments and the risks and benefits, so it's not a consent. It's not really much of an advanced care plan either, because it's so generalized. Is it really going to give her family members much guidance, or the health professionals in the emergency? Pretty loose. And unfortunately, I think that what happens is this kind of form is very misleading to the staff at the home. So think back to the story I told earlier about that she signed a form 5 years ago, because people think there's so much credibility in a form. We need to watch out for this potential abuse, misuse, because it could be treated as a consent to guide to treat Mrs. Smith. Now, if she's not capable, is the daughter her SDM or just the person in the family that's available to assist Mrs. Smith? So is her daughter really the highest ranking person on the list? It may not be. Maybe she had done a power of attorney. If Vera is the proper SDM, it's not a consent, because Vera would need her information on her mother's present condition. When you're the substitute, you're entitled to the same information the patient would have been entitled to. It's not a plan of treatment because it's too generalized. It's not specific to the treatments. It won't meet that standard of what is consent and what's an informed consent. And Vera can't advance care plan as only her mother, when capable, can advance care plan. And if Vera completes it, it could be very misleading. So again, it's with high potential for misuse. If Vera is the proper substitute, she can give consent to the plan of treatment that includes reference to the CPR if Mrs. Smith's present health condition is such that CPR, no CPR would be an appropriate discussion considering her condition, that Vera has all the information about her health condition, she's given all the information about the treatment of CPR, its risks and benefits. In these circumstances, Vera then is not advanced care planning, she's giving consent. So consent to a plan of treatment, current health condition where implications are known, advanced care plan, future health condition, the implications for which may not be easily known to the person. So in conclusion, I think we need to understand what consent and advanced care planning is in the context of Ontario law. So we need to understand it from our jurisdiction. So we need to review policies and practices to ensure that the policies we're using in fact reflect Ontario law. There's a need to get an informed consent from the patient if capable, substitute if not. So understanding that papers don't talk to the health professionals, people talk. So we need to get the directions from people. We need to encourage good communication between the parties. So indeed, people's wishes are honored in the right context. Advanced care planning is not consent. I think it's a very important process. It helps deal with what could be potential conflicts in the future. Getting an understanding of what the patient wants or doesn't want gives a chance for the substitutes to accept the fact that their relatives may not want certain treatments. So it's a good process to go through. And advanced care planning helps the patient communicate their wishes. But using advanced care planning documents as consents is not patient-centered, and it could be subject to challenge, and then we get into issues of liability. And ultimately, we don't want to go down that path. We want people's rights being respected, and we want health practitioners knowing that with confidence that they've got the proper consents. So thank you. This has been it's been a long time. I hope this is helpful, and thank you for the invitation.
Do you want to entertain any questions at this point?
Sure, we might be out of time.
Does anyone have a question that's here?
Check with your sister.
So is that off?
I have none at the present time.
All right, well, since we let you off easy, Judith, I wanted to thank you for your talk this afternoon. I have a ceremonial mug for you, not in my hand, but there is one that exists, so
Well,
here
thank
we go.
you very much.
Here we go. You can add it to your collection. I'm sure you don't want to.
Thank you, thank you.
There you go. Thank you very much, Judith.
Thank you.
Thank you, Judith. That was really important.
Now I'm going to tell you, usually I do something that's much more interactive, but I was assuming because you've got this webcast thing, I wasn't sure how to do it, so I apologize that I wasn't sort of going back and forth a bit more.